Hi, my name is Kyle Farmer. I'm a business immigration attorney, and I help strategize with employers on how they can legally fill their labor shortage needs. Before we get started, I want to get into a little bit of housekeeping, and I want to welcome you to our very first webinar Wednesday. We are going to be doing these in a multi-part series. We're going to start off with basic H-2A. What is H-2A? We're going to move into the more complex issues that arise with the H-2A visa program. People that are going to be in here are going to be from a wide range of H-2A knowledge, from people that have no idea what H-2A means to people that have been filing these applications for a really long time. So it's kind of important to go into that, particularly if you're someone with a bunch of background knowledge. So just kind of hang in there. We're going to get into a lot of the complex issues that arise with the H-2A visa program. If you have questions throughout the presentation or comments, you can leave them in the chat and we'll get to them during the Q&A. If you have specific topics that you would like us to cover, just go ahead and email us at info@farmerlawpc. Mention that you were here on the webinar and that you would like to see X topic covered, whatever it might be. And I'll be more than happy to do it. In the meantime, if you could just leave your questions in the chat, we'll get to it during the Q&A, but let's go ahead and get started. So first, let's talk about what is the H-2A visa program. An H-2A visa allows a U.S. agricultural employer to bring foreign nationals into the United States to perform temporary agricultural work. Now, even within this initial sentence, there's some things to really pay attention to and some things that people oftentimes overlook. And notice that it says temporary. We're going to go into the definition of temporary and what that really means, because there are some things that are obviously temporary. Now, every year I need someone to help harvest my strawberries. Okay, that is temporary. It's obviously seasonal. But there are things that are not as obviously seasonal. So we will go into that later on. That's going to be more of the complex issues that we're going to get into. The other word to really pay attention to is agriculture. We're going to go into the definition of agriculture later, not later today, but on a future webinar, where we get to actually discuss, okay, what is agriculture? What's not agriculture? Things that you might think are obviously agriculture, the Department of Labor doesn't see them as agriculture. Things that you think, no way that's agriculture, the Department of Labor might see it as agriculture. So we're going to go into that. But it is important to point out from a compliance perspective, if you're bringing in H-2A workers, it's important that you don't have them performing work that takes them outside of this definition. For example, if you're a dairy farmer, but you also have corn and soybean crops, and so you bring in H-2A workers to help you plant and harvest your corn and soybeans. Well, while they're there, you can always use help in your barn milking the cows. So the issue that arises whenever you have those workers performing the milking of the cows is the Department of Labor knows in an audit that is not a temporary or seasonal occupation. So you're misusing the H-2A workers, something they get really mad about. Also, agriculture. The reason we're going to go deep into what agriculture means is because it's similarly important that you don't have them doing work that's non-agricultural. You bring in these workers to perform temporary agricultural work. So we'll go deep into both of those terms, but I did just kind of want to lead off with that. Even the most basic, what is the H-2A visa program, leads us to some compliance questions. So we're going to have some fun. This is one of my favorite aspects of the H-2A visa program. Is unlike the H-2B visa program, which has a numerical cap of 66,000 visas a year, 33,000 for work starting on October 1st, 33,000 for work starting on April 1st. The H-2A visa program doesn't have a numerical cap, which is great because it means that whenever we apply for visas, we know we're going to get the workers. So that's one of the really good things. That the cap in the H-2B program, which I guess for those that aren't aware, the H-2B program is very similar to the H-2A in a lot of ways. It's kind of the non-agricultural sister visa program of the H-2A visa program. Obviously it's a very popular one because that cap is extremely competitive. Luckily, in H-2A, it's not something we have to deal with, so that's great. To show how popular the H-2A visa program is, in fiscal year 2020, there were over 213,000 H-2A visas issued, which is pretty interesting. You can look at this chart, and this chart shows the history of the H-2A visas that were certified, number of visas issued. So and it's since 2005. The x-axis there shows 2005 to 2020, so it's a 15-year period, and you can see how it went just way up since then, since 2005. The reason that the number of certified positions are higher than the number of visas issued is because not every position certified actually turns into a visa. Let's say I'm a strawberry farmer and I think I need 20 people. I think I need 20 people. So the Department of Labor certifies me for 20 people. Well, once I get my certification, I get 15 people and I realize I didn't actually need those other 5. Dang it. Well, that the Department of Labor still certified all 20 spots. So that makes the blue line higher, but they only had we only had 15 visas issued. So that's why the orange line is lower. But as you can see, regardless of which line you're looking at, it significantly increases over time. This program has got really, really not competitive, really popular. No cap, so not competitive. But it has got really popular, and I expect it to continue to get more popular. However, I don't think it's going to increase as a percentage as it has since 2005 in the future. Wages are just simply getting too high. But I do think it's going to continue to increase in overall number of people being brought in on H-2A visas. Okay, so now let's talk about who qualifies. So to qualify, a petitioner, the company, must offer a job that's temporary or seasonal in nature, the one we talked about, demonstrate that there are not enough U.S. workers who are able, willing, qualified, and available to do the temporary work. If through this process you have able, willing, qualified, and available U.S. workers apply for the position, you're required to hire them. We'll go into that here in a second. But and then the petitioners also must show the employing H-2A workers will not adversely affect the wages and working conditions of similarly employed U.S. workers. Okay, so you're an agricultural company. You want to hire H-2A people. What are your obligations in the hiring process? So throughout the process, I guess the very first thing that you do in an H-2A visa filing is you file a job order, ETA 790, with the state workforce agency. And the state workforce agency posts the job on their system, and they make this job available to U.S. applicants. You're required to abide by non-discriminatory hiring practices. This is something that you tell the government you're going to do in this process. So you must be open to hiring any qualified U.S. worker, regardless of their race, color, national origin, age, sex, religion, handicap, or citizenship. But it does lead you to wonder, okay, well, what is a U.S. worker? Is it just citizens? And it's not. It's a little more detailed than that. And we're going to go into a couple examples that oftentimes confuse some folks. So a U.S. worker is defined as a citizen or national of the United States, or an alien who is lawfully admitted for permanent residence in the U.S., is admitted as a refugee, is granted asylum, or is an immigrant otherwise authorized to be employed in the U.S., or an individual who is not an authorized alien with respect to the employment in which the worker is engaged. So in simpler terms, a U.S. worker is anyone that is in the U.S. with lawful working status that applies for the job. So that's now where do some of these complications come up? Okay. And this happens every year. This is a really common one. I am an H-2A employer, and I have a H-2A employee for another company apply for my position. They saw the posting on the state workforce agency's website. They want to apply for the position. So they email me. They say, here's my resume. The question is, do you have to interview that person? They are able, willing, or they're willing and qualified at least. Do you have to interview them? Well, the answer is no. And whenever you get an H-2A visa issued to you, or the employee has an H-2A visa issued to them, it is specific to their current employer. So they're not a citizen or national of the United States. They're an alien who's lawfully admitted, but they're not for permanent residence, so that they want to check that box. They're not a refugee. They're not granted asylum. They're not an immigrant otherwise authorized to be employed in the U.S. because they're not an immigrant. They're a non-immigrant. So they're not an individual who is not an unauthorized alien with respect to the employment in which the workers engaged. So you don't have to hire that person. Another example that comes up all the time, every single year, this one comes up too. You apply for H-2A people. State workforce agency posts your job on their website, and someone from the Ukraine applies for your job. Do you have to interview? Again, the answer is no. Again, because they don't meet any of those requirements. Now, let's say that you have someone that emails you and says, hi, I would like to apply for your position as a farm worker. I am on the DACA program and I have legal working authorization. Do you have to interview that person? The answer is yes. That is a U.S. worker. They're someone that's protected under our current immigration laws, and they are authorized to be employed in the United States. So it can be a little tricky sometimes, the type of people that you do have to interview. If it's a U.S. citizen, you always have to interview them. And another really important point here, whenever you're thinking about H-2A compliance, what I like to teach our clients is the first thing you should think about whenever you're wondering if something is compliant, if you should do a particular thing. The first thing that you should think about is, okay, could this thing I want to be doing be construed as adversely affecting U.S. workers? If that thing could, then the answer is don't do that thing. And the other aspect of interviewing people through this process is you want to be extremely thorough. You want to document everything. If you have, let's say that you post your job and you have someone apply for the position, whether they are someone applying from the Ukraine or someone that is applying from the United States, it's an actual U.S. worker. Either way, you want to document what happened with that applicant and put it as part of your recruitment report. We'll go deep into recruitment reports in the future, but for now, just suffice it to say that you want to document every interaction that you have with a U.S. worker or a non-U.S. worker through the recruitment process. And this issue comes up a lot, and we'll kind of get into that in just a few minutes. But the issue of interviewing U.S. workers, who is a U.S. worker, it comes up every single year. So it's just something to be aware of. And remember, if you file H-2A applications, you are obligated to hire any able, willing, qualified, and available U.S. applicant or U.S. workers that apply for the position. So no, you can't use H-2A workers to replace U.S. workers in a labor dispute. So the employer must assure that the work site for which they are requesting the H-2A certification does not currently have workers on strike or being locked out during the labor dispute. So this is important to notice that this is specific to the work site. It's not specific to the employer. How would that make a difference? Well, let's say that you have workers on strike at a farm and you don't want the exposure. It's your farm. You don't want the exposure of replacing these people with H-2A workers. So you hire a contractor. And you hire a contractor, the contractor brings in workers to help you with your harvest. And they're replacing these striked workers. Well, that person now violated the H-2A regulations because they brought in, even though they're a contractor, they brought in H-2A workers to the work site. It's the work site specifically, where there is currently a lockout during a labor dispute. So just remember, it is very specific to the work site. And again, if you're just always go back to that thought of, could this thing that I'm doing be perceived as adversely affecting U.S. workers? Obviously, replacing U.S. workers with H-2A workers could be adversely affecting those U.S. workers. So don't do that thing. It's pretty simple. That should always be the thought that pops into your mind, because that is one of the things that the Department of Labor is most concerned about, and a lot of the regulations are designed around that particular issue. So, is this thing that I'm wanting to do able to be perceived as adversely affecting U.S. workers? If the answer to that is yes, don't do that thing. So the recruitment requirements, what they used to make us do for both H-2A and H-2B actually, was they made us post newspaper advertisements for every application that we would file. It would usually be in 3 states, including in the area of intended employment. They stopped doing that, I believe, in September of 2019. But just as a precautionary note, the DOL they may still require newspaper advertisements. And you would know this on the notice of acceptance. It notes if there's additional positive recruitment requirements. So that's where you would know. But an employer must work with the state workforce agency by accepting referrals of all eligible U.S. workers who apply, consistent with the 50% rule. So the next question is, what is the 50% rule? So the 50% rule requires that the employer to hire any qualified, able, and willing U.S. applicant from the time the foreign workers depart from the employer's place of employment until 50% of the period of the work contract has elapsed. So one question that comes up occasionally, but not very often, just because this scenario doesn't happen a lot from my experience, at least with the companies that we've dealt with. I haven't had to deal with this very much, but it is part of the regulations. So what happens if I apply for 30 people and I don't have a U.S. applicant until I bring up all 30 of those people? And I know, I've been doing this for 50 years. I know that I only need 30 people to perform this work. I don't need 29, then I'm shorthanded. I don't need 31 because then I have too many people. I know I need 30 people. So I brought in 30 people, and then the week that I brought in those 30 people, 5 able, willing, and qualified U.S. workers applied for this position and accepted the job offer. So now I have to replace, this is called H-2A worker displacement. The good thing is that you as the employer aren't liable for the 3/4 guarantee because of compliance with the 50% rule and the H-2A worker being displaced. However, it is something that you need to be aware of because there are notification requirements and there are document requirements that you want to make sure that you take care of. But yeah, if you bring in 30 people, you need 30 people, and you have 5 people apply for the job, and it's a week after, so it's well before 50% of the work contract has elapsed, then yeah, you're required to hire those U.S. workers still, and it displaces the H-2A workers. It's just part of the process. Remember, again, if you're thinking back on it, is this thing that I'm doing going to hurt able, willing, and qualified U.S. people? Well, if I deny their opportunity for this position, because I have all these H-2A workers, then yes, you having those H-2A workers hurt those U.S. people. So there's a rule prohibiting unfair treatment. Employers cannot discriminate against or discharge without just cause any person who has filed a complaint, consulted with an attorney, or an employee of a legal assistance program, testified, or in any manner exercised or asserted on behalf of himself or herself or others any right or protection afforded by Section 218 of the INA or the H-2A regulations. In simpler terms, do not intimidate, threaten, restrain, coerce, blacklist, discharge, or in any manner discriminate against anyone, even if they filed a complaint against you to the Department of Labor, caused a Department of Labor audit of your company, testified or consulted with a legal assistance program or an attorney about their rights, or is about to testify against you. This is a tough one. This is a tough one in all of employment law. Whenever you have, because it's so human, the response is so human to be mad and to want to get back at the person that is filed a complaint against you or whatever it may be. It's such a human response to want to do that. And so there's this requirement that you don't, but everything in you wants to do that. Well, you do kind of have to fight that. You have to fight that with H-2A workers. You really have to fight it with anyone that you employ, but there's a specific prohibition in the H-2A regulations again about doing that to H-2A folks. So this is a tough one just because it's so human to have those feelings, but then you do have to combat them. So if you're looking for more information or to speak directly with me, you can just call me at 512-894-2128, or you can email me at kyle@farmerlawpc.com, or go ahead and visit our website, farmerlawpc.com. You feel free to email us. You can email me directly here. You can email info@farmerlawpc.com if you're looking for additional topics that you would like to see covered. We can, and also just as a gift to you for participating, which we really certainly appreciate, that we would like to offer a free introduction to H-2A employment and compliance session with my compliance company, Ag Workforce. It's one that I own. We'll review your company's ETA 790, which is your work contract between you and your employees. We'll go through the whole thing with you. We'll give you an overview of recent DOL announcements for agricultural employers. And while we do come to this with an agenda, the whole purpose of it is to just answer any questions specific to you that you might have. So we give you the time to ask any questions that you might have about H-2A compliance, about the regulations, about something you're doing, how to modify it, how to make things more efficient. We're more than happy to help and have a ton of experience doing it. So feel free to reach out to us to take advantage of that. We would be more than happy to run you through that. Again, it's completely free. There's no reason not to do it. We look forward to getting to know you and getting to know your H-2A visa program and helping you out. Now we can go ahead and move on to the Q&A. Thank you for participating.